also leave. The next case of the day then is Charter West Bank versus Riddle.
This is a
Mr.
this is
Riddle, good morning to you.
this is a court case against a person and a bank that is in a sort of a dilemma over a loan that the customer backed out on because they didn't like what their bank was doing or something like that. But anyway, this is not about the case. This is about how the communication goes in this courtroom. I want to show and how you should pay attention to the way the judges speak and the words that they talk about and the way the person speaks.
Members of the gallery, my name is Justin Riddle. This is my wife, Erin Riddle. We're here today as pro se litigants in this matter. Our lives, like anyone, were constantly evolving. After several years of hard work, saving, budgeting, and debt reduction, we were ready to purchase a home. We worked with Charter West, but at a point in the process, we were uncomfortable with their operation, decided to withdraw our loan and work with a different bank. In retaliation, Charter West put a code in the FHA system that indicated a non-existent child support obligation was past due. This prevented us from consummating our agreement with the new lender, as it's a system that every lender uses, but only the lender who put in the code could fix. After months of bootless requests asking Charter West Bank to correct the record, it was clear they were not going to remove the lies, so I proceeded to file a lawsuit. When it became obvious that we were not being treated fairly by the court, I decided my best course of action was to make a public gripe website. I researched the laws, and once I understood what was allowed, I alone, without the consent or knowledge of my wife, went to GoDaddy and searched for a suitable URL.
Mr. Riddle, just more for the benefit of the folks watching, the court to which you referred where you felt you were not being fairly treated, to what court were you referring to?
That would be the district court, the appeals court as well.
In
In the federal system.
So not in the state court system?
Well,
The one you were
It
talking
was-
about was the federal district court, and which then was appealed to the Eighth Circuit Court of Appeals.
correct.
Now, you may get around to something else, but I just want everyone to understand what you were talking about.
Thank you.
You're welcome.
Your initial lawsuit was filed in the federal district court,
Yes,
all right, and there was motions to dismiss. The court dismissed certain parties, and did you appeal that to the Eighth Circuit?
I did.
Okay. And then you filed is there another action now in state court that we're here on today?
Yes, that's where I'm getting to.
All right, very good,
Thank you.
Okay, did you notice how when the judges were speaking, that they were speaking very clearly, very kind of slowly, and when he responded, he would say, and when he would speak, he would also say the word, every once in a while, and even that one judge kind of cracked a smile when he said that word. So, but there's also another thing that the judges do that could make somebody in this person's position look more professional, is that the judges, if you know, I do this too, they will start to speak and they'll have to start the sentence over again. They'll be like, you were going to do that like that. Like, you'll notice that the judges will stutter a little bit every once in a while when they speak back to him, but he shows more of I'm not gonna say this is me trying to think, because I'm not in a court case right now, but I'm trying to think that he looks more unprofessional with his words versus the way the judges are acting and speaking towards him. In a court, the words and the way you present your words is very important in a courtroom.
Incredibly, CharterWestBank.com was available. I immediately purchased it and did additional research to verify I could legally use that URL. According to the Lanham Act and a very clearly defined fair use doctrine, Because I'm not a competing business and my site is entirely set up to criticize, I am legally allowed. Charter West has decided to sue us for that website based on the Anti-Cyber Squatting Act, which brings us here today. Cyber squatting was the choice for the plaintiff, as it's the one and only way that someone can obtain a website by force. There's no other remedy in law that forces the transfer of internet real estate. However, Charter West has fallen short on their claim on every avenue, and I'll explain how.
Just to, again, be clear for the benefit of our audience, the Cyber Squatting Act to which you have referred is part of the Lanham Act, but there are other parts of the
Certainly.
Lanham Act.
Certainly.
And when you were talking about having researched the Lanham Act, you were perhaps talking more broadly than just the Anti-Cyber Squatting Act?
The fair use doctrine was more broadly, but as far as the Lanham Act, I was very specific with cyber squatting.
That's, okay, that's what you're talking about.
Correct.
All right, thank you.
Thank you.
Let me just pursue that from a,
You see how she said, let me, let's see, she had to start her sentence over and said, but if he spoke in the same fashion that they are, almost like a computer speaking to you, and not say the word and not repeat your sentence or start your sentence over again, or cut your sentence off mid-sentence and then start a new sentence, you know, just any kind of poor communication like that done in a courtroom is very noticeable. And and if you're more professional about the way you communicate in a courtroom, the better you look versus the way everybody else will look.
statutory standpoint. So this case is in the playground of the anti-squatting statute.
Mhm.
Okay. And there are elements that would need to be proved by a party claim.
Precisely.
Okay. And generally speaking, what are those elements?
Well, to qualify for protection, one must either hold a trademark or be so well recognized on a national or global scale that their name would be sufficient for most individuals to know who they were. Charter West does not hold a trademark to my domain name, although if they did, the fair use is affirmative, and I've proven it several times.
When you say they don't hold a trademark to your domain.
Yeah, they're not
Well, I
trademarked.
just, hold it.
Oh,
So,
sorry.
To be precise, I mean, you don't trademark a domain name, you trademark a name.
Correct.
And your contention is they do not have a trademark for
Charter West,
Bank.
correct.
So the statute and the cases are referring to mark, not trademark in the,
Service mark, trademark,
well, they're not fungible. So
You see how specific they're being with the words? They're saying it's mark, but not trademark. You see that you got to be very, very specific and very careful about how you use words in a courtroom, because something like a mark or trademark, those are two different things in a courtroom. That's why the judges are pointing this out to him.
under the anti-squatting statute, the mark needs to be confusingly similar, right?
The mark.
that would be one,
That would be one
one's,
of the elements,
Mhm.
right? But it's not the same as
She's calling
trademark
it the
of
mark.
likelihood of confusion. They're not the same. Do you agree?
See?
I would agree, yes.
Thank you.
Thank you, Your Honor. Additionally, notwithstanding the rest of the world, most people in Nebraska don't know whether Charter West is an Oregon-based shipping company, California travel agency, or Nebraska bank, because they're not well-known and large, thus disqualifying them from the other prong. In case,
There are two words used in the phrase to which I think you are referring, distinctive or famous.
Mhm.
Are you talking about both of those words, or are you talking about just famous?
famous.
You see how specific the judge is being? He's like, I heard two words in there. One was famous. Are you talking about this or famous? So see how he's being very careful about what words he says and he's asking specifically what he means about the two words that he just used in his sentence just then.
What about distinctive?
It's not trademarked, so doesn't have any, there's no protection for that.
When you say it's not trademarked, are you saying there's no evidence that they have a registered trademark?
Correct.
The USPTO?
Would I be able to step to the next prong? I think it'll answer all the questions. Thank you.
Sure.
In case the lack of qualifying conditions does not on its own satisfy the court, there is a second, standalone, fundamentally more important area the claim fails. Public criticism, parody, gripe websites are constitutionally protected activities. When I purchased the site, I immediately started cataloging the way that Charter West had fabricated information to damage us, the little guy. It's easy to explain through a website. I'm going to skip some of this. But in order to win this case, Charter West must prove I was acting in bad faith. This is simply impossible to do based on the factual and legitimate gripe that initiated my complaint prior to purchasing the website.
It seemed that the district court, the state district court was concerned about the offer to sell the website for $1 million. Does that have any impact?
I'll skip ahead to that. You will see an email string from the plaintiff titled "Settlement Offer Withdrawal" was allowed into evidence despite my objection because, as Judge Durr insisted, quote, "It's not an offer of settlement because there could be some more nefarious information contained," simply meaning that he would allow those emails with an open admission that he could use them as a fishing expedition. So
See, he just said again.
let's just skip to the, because we're running low.
Before you move on, with regard to your bad faith argument, are you saying there could not be bad faith here because what you were asserting was true?
Correct. It's not only true, it's legal. And I haven't impersonated the bank. I haven't tried to sell bank products. Anything is for sale. If the bank wants to buy the website, I can sell it to them. That's not cyber squatting. I mean, it's defined, and I just haven't done that.
It's defined in that bad faith has 9 statutory factors of bad
Correct.
faith, right? 15 USC 1125
Look at-
D1,
bad faith has
D
no-
little 1. Did I do it? Okay, so.
9
right.
statutes
And there are
of
other
Not
things that
exclusive.
can be considered as
Right,
well.
Right, and that is kind of a reference for analytical.
Exactly.
purposes.
You see, there's 9 different meanings of just that one phrase. That's pretty crazy. See, that's how specific you have to be in court. This is supposedly the Supreme Court. I don't know how, you'd think the Supreme Court would look a little bit more grand than this, but supposedly this is the Supreme Court of the United States.
Right, okay.
And then I would also like to mention, if there's any remaining doubt, all one needs to do is visit www.nissan.com. You'll see that it's currently owned as a gripe website, and that www.nissanusa.com is what the world's 9th largest car manufacturer and 157th largest company owns. I pray the court upholds the same decisions as every other high court in, regarding gripe websites and move them to dismiss with prejudice, as there's really no other legal question to answer. I would like to reserve my remaining time.
You may.
Thank you.
Thank you very much. Mr. Silver, good morning to you.
Good morning, Mr. Chief Justice, Your Honors.
This
My
guy
name is
must
Jeffrey
represent-
Silver. I
must represent the
have
bank.
privilege of representing Charter West Bank in this matter. This is not a freedom of speech case. This is an internet blackmail case. What this gentleman did was buy a website that he found that unfortunately for Charter West they did not have, and he bought this domain site, and he did it for one purpose only, and that was to injure and damage Charter West. The emails that are part of the record, I think, reflect astonishingly what his bad faith is, if I may.
May I jump ahead? And
Sure.
that is, I think you mentioned this injury to Charter West. What is the injury to Charter West on this record?
The injury to Charter West on the record is the confusion that it's going to cause with respect to its website that it has, that we have in the record.
Is that prospective, or is that already happened?
I'm sorry?
Is that prospective, or has that already happened?
That is, well, in one of his emails, and I'll reference
It
it for you,
should have been
Mr.
a
Chief
yes or
Justice,
no question.
He says the damage is going to happen, and we're not
So
even
it
gonna
hasn't
know
happened
about it.
yet.
So the fact of the matter is, there may be damage happening to us.
But then you're all speculating.
Yeah, you're
Well,
speculating.
You can't speculate about the damage because he's telling us in his email that the damage is going to occur and we're not even going to know that it's occurring.
Well, I don't, is this your proposition that some navigational miscue results in damage automatically?
No, it's not it's not a navigational miscue. It's an intentional, purposeful attempt by Mr. Riddle to damage the bank by having his website, or this website, put up and make believe it's Charter West Bank.
But that, I think you answered it with the answer to, was there evidence of bad faith? And evidently you believe so, and we
Yes,
accept
if I-
that.
if
Okay, yeah, see,
if I
that's
may.
what, he should have answered
What
yes
about
or
all
no to
these
the first
cases
question.
that seem to say gripe websites are permitted. Do you disagree with those cases, or is this case distinguishable from those?
This is not a gripe site. I understand that gripe sites are okay. If somebody wants to make a gripe site about Charter West being really bad and not doing everything, that's fine. That's certainly protectable. This is not a case about a gripe site.
What distinguished this? from those
Because
cases?
in his, if I may,
You see what he's doing right here? He's trying to pose an argument about the other guys suing the bank for not letting him get a loan from another bank by invoking some law, and so he got a website and he's trying to prove that he got this website to blackmail them based on it being similar to the web page that the bank already owns, and now that's his case, and he's trying to prove that. That's why the judges are being so specific with their words. That's why he's trying to be very specific about what he's trying to claim, and it's going to be a much more complicated case for this lawyer right here for the bank than it is for the person, the person who got the loan. Looks like these people have perked up a little bit. This girl still looks like she's kind of bored as hell. This looks like some interested parties back here. We're going to go ahead and stop this video here. This will be part 1, and we'll do part 2 based on the results that I guess this video gets. But this is how you should speak and present yourself, and how you should say your sentences in a courtroom. No saying the word being very clear with your sentences and not try to repeat or start your sentences over when speaking. The judges are very clear and well spoken, and even the lawyer is kind of well spoken, but he's got himself quite the case to try to go through with the chief justices here. And he's got one big job for him, so to be continued.